Right hands for me. Do you swear or affirm to tell the truth? Sir, we have family in here, I believe.
Were you on bond or pretrial release? Do you have any pending cases? Have you ever
Could I have both of you raise your right hands for me? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, put your hands down. Now, ma'am, tell me your name.
Chanel Pender.
How do you know Mr. Caldwell, Miss Pender?
He's my cousin.
Okay, and your name, sir?
Rodney Woods.
And how do you know Mr. Caldwell?
I'm his uncle.
Okay. Now, he's been charged with resisting arrest and violating a pretrial release condition. Do you know Jamara Mitchell?
Yes.
How do you
That's the
know
mother
her?
of his son.
That's the mother of his son.
Okay, got it.
Yeah. She was here.
Excuse me?
She was here. You just issued this no contact order yesterday, Judge.
Did I?
Yeah.
You know, I'm getting
I'm
getting old, and
no.
I get overwhelmed by facts.
Yeah, no, I completely understand. No, he was arrested Monday and then came through here, I believe, Tuesday morning on a domestic violence by strangulation. You ordered no contact. He got out yesterday. I believe the victim did appear. It might have been towards the end of the docket. I don't entirely remember at what point she was here. You set a $5,000 bond, ordered no contact.
Okay.
We have issue with probable cause affidavit.
Okay, hold
Are
on.
you taking certain medicine right now?
Yes.
What are you taking?
No, I'm going
For your neuropathy? Okay. No? It's just that. When's the last time you took it? When's the last time you took it? 2 weeks ago? 3 weeks ago? A month? A month? Are you very tired or are you peaceful? Okay. Are you receiving Medicaid or Social Security disability? You're receiving Medicaid? Okay.
Okay. What is your argument of probable cause, sir?
Judge, regarding count one, I would argue that refusing to put one's hands behind one's back, putting one's arms at one's side, and balling up your fist is not an act of resisting. It did not prevent the police from placing him into handcuffs, and I would argue there's no probable cause for count one. As far as count two, Judge, the evidence in the probable cause affidavit indicates that he was inside the house and the alleged victim in the case was outside of the house. So when the Child Protective Services person came up, she was approached by the alleged victim who was outside of the house with the child. If he had custody of the residence, okay, he has no control over where she goes after she gives him custody of the residence. Okay, so for her to be where the Child Protective Services officer was does not mean that he violated any restraining order. She let him have the house. He moved into the house. He has no control where she goes after that. So he did not actively violate the restraining order. According to the probable cause affidavit, there's nothing in here that says that he knew that she was on the premises or that she was even on the premises. And so he has no control over that. So I would argue there's no probable cause for count two. I ask the court to release him on his own recognizance on both counts.
Yes, sir. The court also finds there's no evidence which would back up your version of the facts, which state that he got the house or that she didn't have the house and he was controlling the house. If you have those facts, I'd appreciate where you're getting them from.
Okay, so on the second page, second paragraph. Before Ms. Roberts could exit her vehicle, she advised a black female walked up to her car asking what she was doing there. So she was outside of the house when she walked up to the car.
I get that. I understand.
Okay. All right, and then in the next paragraph, it says the defendant was actually inside the house.
I understand that.
While the victim was on premises.
Right.
There was no evidence that she was on the premises or that he knew she was on the premises. He was inside the house. He has no control over what she does when she's outside of the house, Judge. There's no evidence that he knew that she was going to be there. Therefore, he is not willfully violating the court's order.
Yes, sir. Thank you. The court will find probable cause to both counts. State, what is the open case?
The open case, Your Honor, it's strangulation.
Go ahead.
It's, one moment, I just want to... Domestic violence battery by strangulation.
What's the case number?
154974 CF10A.
So today, the court will revoke your bond on 154974 CF10. That bond is revoked. Count 2, that bond's $2,500. Count 1, you'll be released to ROR. The court will just remind you, you're not allowed to have any direct or indirect contact with Ms. Jamara Mitchell. Thank you.
Judge, once again, I'm just ask the court to reconsider. There's no evidence that he had any contact with this woman.
Sir,
no evidence at all that he had any contact with this woman.
Sir, you made your point and the court's ruled. I appreciate that. Thank you very much.
Once again, I'm just advising the court because you're going outside the probable cause affidavit to find PC in this case.
We're moving on. You don't need to keep repeating yourself. We're moving on. Thank you.
Mr. Londeray indicated he'll be here in 20 minutes.
Can you find something to do for 20 minutes?
Sure can.
Thank you.
Sure.
Avenant, Elise.
Sure. Come here, I got stuff for you. Come here, I got stuff for you.
We need a Creole interpreter, Judge.
Okay.
Come on, it'll be a fun experience. It'll be a fun experience.
That's right.
Okay. Now see, Piotr Rook.
North Broward, Judge. North Broward, Your Honor.
Yeah, Michelle.
Mr. Rook, you're charged with domestic battery. The court finds probable cause. State, are there any priors on this, gentleman?
Madam Pretrial.
Sir, how long have you lived in South Florida?
10 years?
And are you currently employed?
Yes.
What type of work is that?
I'm a pipe fitter, pipe welder, and Metcalf Marine Exhaust in Fort Lauderdale.
Do you have any money in the bank?
Do I have any money? I have
Yes.
some money.
Okay.
Yes.
Do you have children, sir?
Matches.
Excuse me?
Do you have children?
Yes.
Okay, how many?
Name of the case you're revoking.
One daughter, 12 years old.
Does she live here with you?
No, she does not. She's in Michigan.
Okay, got it. Steve, do you have any criminal record on this defendant?
Checking through pretrial, Your Honor.
1997 adjudication, domestic battery. 1997 assault with
But when you write the charge, has to match the charges there.
NCIC out of Detroit, Michigan, 1997
And
assault
I want to confirm on PSO how he got out. In this case, it was a bond, so in this case, you're revoking.
Sex assault?
excluding sex.
Okay. And that's out of Detroit? Got it.
Because if it's not a bond, then it's pretrial release conditions that you're revoking. There isn't a bond to revoke.
Got
That's
it.
it.
Okay, so, anything?
Yes, she is very concerned about her safety. She goes out.
I understand, 12:20 a.m. Lived together as a family for about 3 months. Allegedly punched her in the stomach twice, scratched her hand. She had a scratch on her left hand. Sir, you've already been convicted of domestic violence in the past. And based on these facts, court's concerned for the safety of the alleged victim. Court's going to set your bond at $7,500 today. The court will order that you have no contact directly or indirectly with Tanya Lovchenko. Do not call her, text her, email her. Stay 500 feet from her at all times. That is where she lives, works, goes to school, anywhere in between. You're not allowed to possess guns, firearms, or ammunition while you're on release. Thank you.
We had a case this morning.
Missy Edward Leahy.
Judge, she's at North Broward. I just want to advise the court that according to Odyssey, there's
Leahy's
still
a medical
no proof-
reset, Your Honor.
There is still no proof of service of any injunction in this case.
Okay. The PC in this case, the officer said, I served.
There is proof. Right in the first line, defendant respondent was served with the restraining order yesterday morning. The order was completely explained to the defendant in my presence at that time. This is under oath. This is a sworn document. So, thank you.
Judge, again, I said, an Odyssey, there is no proof of service.
No.
That's all I said. That's just, Judge, that's just something somebody wrote down. I'm telling you that in Odyssey, there is no proof of service. That's all I'm saying.
Judge, I believe he's a medical reset. He's medically
Originally you
reset.
said there's no proof of service. Now you said there's no proof of service in Odyssey. That may be true.
Judge, that's all I've ever said.
That, just because it's not an Odyssey doesn't mean it didn't occur.
Judge, but besides the point, he's not
Judge,
there. It's a medical reset.
All I've ever
so I would just
said
ask the court to
was
reset it for
Odyssey is
tomorrow.
showing, Judge, all I've ever said is Odyssey is showing there's no proof of service. That's it. Okay, I haven't said anything else about the case.
Thursday PM. There you go. Thomas Poplowski.
President of the Maine Decline PD.
Sir, you wanted out of state, that is out of Virginia, on a forgery charge. You can be held without bond, and I will see you in extradition court perhaps tomorrow, perhaps Monday. Thank you. Jessica Delorme, Adela
North
Brady,
Broward.
Portia Rutledge.
Delorme is North Broward.
Okay.
Your Honor, Ms. Delorme is a medical reset.
Okay, we're gonna just pass this right through. You know, I don't see any court dates in here. Can you make sure she gets some court dates?
Judge, would the court, I understand it's a medical reset, but would the court consider, in light of no court dates at this time, maybe placing it on the second look docket, you know, and possibly resolving it? I don't know her intentions, but
Well, I'm not gonna put it on there to resolve it. My only issue is, ma'am, can you make sure this gets put, transferred to Central, and she gets put on a hearing ASAP? Transfer to Central, hearings ASAP. Thank you. Okay, so we took care of that. Adela Brady,
Bonded.
bonded, okay.
They stay in jail. They automatically transfer them to you guys.
LaPortia Rutledge,
Bonded.
okay.
No, I'm talking about, they've been arrested on the KPS, on the satellite. They can't bond out.
Okay, let me see, James
So
Peacock.
So they're supposed to be automatic.
Main jail.
Mr. Peacock, you have count one, a traffic infraction, suspended license. That's a $500 bond. Count two, a writ of arrest. The purge amount's $509. Thank you.
Judge, would the court consider ROR for the, for Mr. Peacock to play the purge amount
No,
on count one?
I'm gonna let him on count one and two, just stay the same thing. Hugh Lewis.
Judge, can I give the court some background information on Mr. Peacock before you make your decision?
Go ahead.
Judge, he's a 24-year resident of South Florida. He's lived at the same address for since 1993. He has 3 children he supports, age 10, 16, and 18. The 16-year-old relates to count 2. He is gainfully employed at Masters Marine, where he does yacht refinishing. He's a honorably discharged veteran of the United States Navy, where he was a bosun's mate 3rd class. We ask the court to reconsider an ROR in count 1 and allow him to pay the purge amount and take care of this case.
Okay. Sir, how long were you in the Navy?
4-year enlistment, sir.
And what did you do on it as a bosun's mate? What did you do? What does a bosun's mate do on a ship?
Everything from maintenance of the ship, chipping paint, running needle guns, painting, steering, both helm and lee helm, all watches, all visual watches.
Tying up the ship, untying the ship, right?
Absolutely.
Right.
All mooring, seeing anchor detail.
Right, okay. I will, the court will use its discretion on count 1.
Thank you, Judge. If it moves,
Salute.
and if it doesn't move,
Salute.
Paint it. Paint it.
thank you, Judge. Appreciate that.
How about Hugh Lewis? Dan, may I help you?
Terrell?
Okay, I'll call you.
What's your name? You.
Do you need to look at them? Yeah, I'll give them.
Yeah, what did he get peak on?
He gave him RR.
He gave RR? You got your court date, right? What was it? Next Tuesday. Next Tuesday. Homovich?
Okay, where's Hugh Lewis?
Present at the main?
Sir, you're charged with violating community control. No bond, thank you. How about Robert Hamovich?
Just went to the restroom. He's coming right back.
Can we get a quick reset on that one, Judge?
Okay, Hamovich, you're,
Hearing
okay.
14, photo order.
How about,
What's that?
you have Charles Flowers?
That's an MO case, Judge?
He's probably doing
Is he up?
Your
Is he
Honor,
still
Charles-
sick? Go ahead.
Charles Flowers is the medical reset.
Okay, let me look here. Here's what I'm going to do on Flowers. I think this, instead of having to linger in this courtroom, I'm going to appoint F.J. McLawrence, and I'm going to have this transferred to Judge Lerner Wren.
Okay.
So
Good.
if it hovers here, he's going to waste time by getting to Lerner Wren. So,
I'll prepare an order, Your Honor.
order, you have the case number?
1009, MO10A.
Okay, and I'm going to sign an order sending this over to Judge Lerner Wren.
Thank you, Your Honor.
And Mr. Homovich is present at the main jail.
Okay, Mr. Hamovich, sir, you're here on a felony battery. The court finds probable cause, sir. Allegedly, your roommate grabbed a beam from a door and allegedly hit him with the beam on the right arm and leg and eyebrows. And are there any priors on this gentleman?
One moment, Your Honor.
I'm going to call you out in just a moment.
Try it again. Okay, he's got DWI out of Washington, D.C. in the early 90s. He's got he was arrested September of last year in Dade County for domestic violence battery. That was dropped. A theft out of Sunny Isles, 2012. Trespass, Miami Beach, 2005. End of record.
Sir, you currently employed?
Judge, Mr. Homovich is retired. He was an X-ray technician. He's been in South Florida for 15 years. That's as far as I got if the court wishes to inquire further.
Sir, do you have any money in the bank?
No.
And you live on Diplomat Parkway in Haldale Beach, right?
No.
Where do you live now?
I was moving to a condo 2 weeks ago. I went and moved in and stayed for 1 week. And the management come and told me we had to move out
Okay.
because the
Well,
condo was
where are you-
not able to get rented.
When you get out of
Very good.
jail, where are you going to go? Where are you going to hang your hat when you get out of jail?
Well, I was at the Night's Inn.
Night cent. Okay, so.
Did you serve in the military?
All right.
Yeah, no.
Do you have any money
Judge?
in the bank, sir?
No.
Mr. Homovich, you served in the military what branch?
Army.
How long were you in there?
6 years.
6 years. Where did you serve?
Vietnam.
Okay. What kind of discharge did you get?
Honorable.
Okay. What branch?
Army.
Okay. And what was your discharge rate? You remember? E5?
Were you drafted?
No, I joined.
And, okay, and, wow. And, what did you do in the Army? What was your duty in the Army?
I was an X-ray technician also
In the Army?
In the Army.
So you didn't?
In Vietnam.
All right, and how long were you actually over there in Vietnam?
A year and a half.
Okay, so you treated people who would come off the battlefield and things like that?
Yes.
Were you actually forward where the action was going on?
No, it was in a field hospital
Okay.
where they transported in.
Do you go to the VA now?
Yes,
Which one?
Miami.
All right, and you do you have a specific address you can go to when you're released?
When you get out, do you have a place to go?
I can find a place. Yeah.
Okay. I'm gonna order. I'm gonna set a bond today of 1,000, but I'm gonna order pretrial pending, PTR pending, and as soon as they find a place for you to live, you can be released from custody. I'm gonna order that you have no contact with Edward Cognac. Do you have any reason to have any contact with him, sir?
Well, he was moving to the condo with me, and all my stuff is in the condo. We will wait until the end of August to move into it again.
Well, you're going to have to
That's
make
all I
other.
was
You're
saying,
going to have to
yeah.
make other arrangements. You can't move in with him. All
Yes.
right.
Okay.
You're going to have to.
Thank you,
stay,
Judge.
You have to stay 500 feet from him at all times. I'm going to order you're not allowed to consume any alcoholic beverages while you're on release. All right.
Sort of where you going?
Thank you.
Thank you, Judge.
Okay.
I used to live like right around here.
Okay. Jose Renderos.
José Brenderos,
Ma'am, do you swear or affirm to translate from English to Spanish, Spanish to English truthfully and to the best of your ability?
yes, I do, as your American Spanish interpreter.
But Mr. Renderos,
Señor Brenderos,
Probably not.
Main jail, Judge.
good afternoon, sir.
buenas tardes, señor.
You were charged with 3 counts of possessing steroids.
Se está acusando con 3 cargos de posesión de esteroides.
Count 4 is DUI.
Cargo número 4 es DUI,
Count
manejar bajo
5
influencia.
Count 5 is a DUI charge with
Cargo número
a
5 es un cargo de manejar bajo la influencia con una lectura de aliento alta.
count 6 is DUI with property damage.
Cargo número 6 es DUI con daños a la propiedad.
7 is driving without a license.
7 es manejar sin licencia.
9 is an open container of alcohol.
9 es judge what?
Open container of alcohol.
Es contenedor abierto de alcohol.
Count 9 through count
De cargo
26
9 al 26
possession of drug
son
paraphernalia.
posesión de instrumentos para la droga.
Court finds probable cause to
El
each
tribunal
every
encuentra
count
motivos
six.
fundados
Theft from last year,
de
result
antecedentes
January of this
anteriores
year.
de enero
What's, is that in Broward?
del año
Yes.
pasado.
Sir, are you currently employed?
Señor, ¿está usted trabajando actualmente?
Sí.
Yes.
What type of work do you do?
¿Qué tipo de trabajo hace usted?
Chef.
Chef.
Do you have money in the bank?
¿Tiene usted dinero en el banco?
No.
No.
Do you own a house? Do you own any land or property?
¿Usted es dueño de una casa, de alguna propiedad, de terreno?
Con mi hermano.
¿Perdón?
No, vivo con mi hermano.
No, I live with my brother.
Right. Do you have any money available to bond out anywhere?
¿Tiene usted dinero disponible para pagar una fianza y poder salir?
Ahora no, mi hermano me va a ayudar.
Not now, my brother is going to help me.
How long have you lived in South Florida?
¿Cuánto tiempo ha vivido usted en el sur de la Florida?
8 años.
8 years.
What does your brother do for work?
¿Qué hace su hermano en qué trabaja él?
El chef.
Es chef.
Judge, I have an argument to make.
Go ahead.
I'm looking, and perhaps I've missed it, but I don't see anything about
Qué
an
bien,
open
a menos de que
container
yo no lo haya visto.
in the probable cause affidavit. Perhaps someone could point that out
I'm
to
not going
me.
to give him a bond on that anyway, so.
And on count, the paraphernalia,
Los instrumentos
there's
de la
nothing
droga.
illegal about owning hypodermic needles, unless they're connected with some sort of illegal drugs. In this case,
Menos de que sea una
the
droga
police
ilegal.
officer did not check with poison control or anyone to determine what was what these things were, and it doesn't
En
indicate
algún
whether or not they're
momento
scheduled
el oficial no le
or
interpretó
controlled
cuáles eran esas
substances. So I'd argue
cosas.
that there's no probable cause
No hay motivos
for the
fundados.
counts relating to the steroids.
The court will find probable cause.
La sala va a
and
encontrar
probable cause is a very
motivos
low standard.
probables.
But the court does note there were 20
Es un nivel muy bajo.
hypodermic needles and 3 sealed boxes
Y
containing
hay
crime
13
lab
cajas selladas o cerradas
steroids. So,
conteniendo los
based on that, I'm
esteroides.
gonna find
Basándome en
probable
esto,
cause.
si yo encuentro motivos fundados.
Judge, I don't know from
Yo
my
no
own
sé
experience, and it
de mi
doesn't say in
propia
this probable
experiencia.
cause affidavit that Teston and Trenbolone are controlled substances.
Que
And
las
so I would
pruebas
argue that
de
there's no probable
tremolón si
cause on
son
this piece of
sustancias
paper
controladas,
to suggest
regularizadas.
that these are controlled substances. And then I would argue that because there's
voy
no
a argumentar.
PC that these are controlled substances, then the hypodermic needles are not paraphernalia.
Yes, sir.
Voy
Thank you.
voy a argumentar que porque nosotros no podemos
So the
todavía
court's
no
gonna
estamos
set your
seguros de que
bond
sean drogas
On
o
count 1, 2, and
sustancias.
3,
No pueden,
1,000 per count.
son $1,000 por cargo.
Count 4,
Cargo número 4,
$500.
$500.
Count 5,
Cargo
6,
5,
1,000.
$1,000.
7 ROR.
7 bajo la libertad y
9 through
bajo su
count
propia palabra. 8, 9,
6, you'll be released on your own recognizance.
26 va a salir usted bajo su propia palabra.
So your total bond today will be $5,500 total.
La fianza total son $5,500, señor.
You bond out of jail, sir. Thank
Puede
you.
usted salir de la cárcel y pagar su fianza, señor. Gracias.
Okay, now,
Bueno, thank you, Judge.
Who else?
Off you go.
Judge.
want to make an announcement?
¿Hay alguien más para español?
¿Quién
¿Alguien
habla
más para
solamente
español?
español? ¿Quién habla solamente español?
Okay.
No, not at the main, Judge.
Thank you. Okay, may I see the following people? Nicholas Dawson, Sean Young, Seth Potter, and Jason Levin.
Thank you, Nice slide, folks.
Judge, I had a chance to speak to the city on Mr. Dawson and Mr. Potter, and I know that the offer was, which they want to resolve if the court would consider it, time served, correct?
Let me ask you this. When was the last time he was in? Do you know Mr. Longeray?
Oh, Mr. Potter or Mr.
No,
Dawson?
I know Mr. Potter.
Pretrial
How about Dawson?
Okay.
Potter's here every week.
Gas
How
bottle
about
down.
Dawson? When was the last time?
What's his number?
UCC 738918.
Last time in was April 18th.
We're going to get the interpreter, Creole
Are
interpreter.
you working at this time,
Solicitation.
Dawson?
No, sir.
Do you have any money in the bank?
No, sir.
Do you own land or property down here in South Florida?
Property? No.
Go ahead.
Solicitation on public roadway.
So panhandling in April, and allegedly now he's doing it again. It says, I want to read here, walking in and out of traffic on Andrews Avenue, 11 o'clock in the morning, soliciting for money, stopping vehicles. Stopping vehicles and soliciting for money.
Sir?
Has been offered numerous homeless outreach services and rehab services. However, he refuses help.
Sir?
Please don't say anything, sir.
Oh, I can't talk back.
Everything you'll be able to do is just
What does
follow
it
the
have to do with, sir?
We don't want no problems. And we don't
I'm
want
sorry?
What do you want to tell him? Just go ahead. What do you want to say?
Everything will be.
Oh, I was going to say I wasn't stopping traffic.
Okay.
I was waiting until they stopped.
Got it, I understand. So I'm going to set your bond today at $250. And would you like me to appoint an attorney for you? I've got a free attorney here in the courtroom. Won't cost you anything. You probably need it. All right?
For panhandling?
Thank you.
Unless you post a bond, you're going to be staying in jail a few days. All right?
What's a few days, sir?
Oh, I don't know. Could be a week, 2 weeks. I'm not sure. Could be 3 weeks. You want an attorney to help you through this?
I suppose.
Okay. I'm going to appoint F.J. McLawrence to represent you. He's the special public defender on this.
Thank you, Judge.
I'm going to ask when you go back out there, when you eventually go back out there, do not panhandle. You're not allowed to panhandle in traffic in the city of Fort Lauderdale, especially at Andrews Avenue and Broward Boulevard, that whole area there. Not allowed to panhandle there, sir, in traffic or around traffic. Thank you. How about Sean Young?
Yes, sir.
Sir, Mr. Young, you're here for trespassing at a Victory Petroleum Mobile. And would you like to resolve this today, sir?
Yes, sir.
Okay. Do you have any reason we can't resolve this?
Judge, he has a felony that was discharged also.
For what?
Possession of cocaine.
Okay, let me ask you this. Did you talk to this gentleman, Mr.
Judge, I didn't speak with him.
Let me ask you, Mr. Young, would you like to plead no contest in the case to be over with today?
Judge, in
Yes.
Judge, in light of his record that I just got, I'm going to ask for 30 days Broward County Jail.
For what?
Judge, just what I didn't have it on. I just got handed to him by my secretary outside. I didn't know about him.
Go ahead.
He has, let's see, April 1st, 2015, possession of cocaine and possession of cannabis. I'm not sure if they're still open. They're in front of Judge Michael Robinson. And then earlier that year, January 22nd, he had a petty theft in the city of Fort Lauderdale and an open container. Then before that, it was an open container. Before that, it was resisting without and delivery of cocaine. He was adjudicated guilty on that. That was in 2011, delivery of cocaine. And then 2010, possession and intent to sell, adjudicated guilty on that, 2010. Then 2009, adjudicated guilty and possession of cocaine again. Judge, he has numerous felonies that are disturbing, and doesn't really done any time on them.
I understand, but you know what? This is allegedly hanging around a gas station.
He may be out. He may be out on bond right now. Though.
Is he out on something?
I need his PCCN number.
662952. Let's be clear about one thing. Mr. Young, you're not allowed to go back to the Liberty gas station. Oh, Victory Petroleum Mobile on Sunrise Boulevard. You can't go back there. Do you understand?
Yes, sir.
Okay, just give me a moment.
He was arrested in March on a, I'm guessing, a drug offense that a filing decision has not yet been made on.
Sir, if you plead no contest, your case is over with today. We're not going to have a trial. It's over. Do you need me to give you an attorney to help you make this decision, or can you go without an attorney?
Yes, sir. No contest. Yes.
You need an attorney?
Yes, sir. No, sir.
Okay, I'll accept that. I'll withhold adjudication. Thank you. How about Seth Potter?
That's it, sir. You're finished.
Double home.
Yep.
Mr. Potter, how
you doing?
How's everything going? How's Joe doing?
Not good.
Actually, Joe Curtis and I simultaneously were ran over by a Goodyear truck. Apparently he's settled and he's got a house now. Yeah.
Okay, I can only
I'm
imagine.
I'm proud of him.
I can only imagine Joe was panhandling at the time he got run over by the Goodyear truck.
Actually, we were just sitting down and the driver drove real recklessly and ran over my knee and his ankle.
Yeah.
Apparently he had to have reconstructive surgery.
Was Joe panhandling just about that time? No.
Nope. Just sitting there.
I was just gonna say if he got hit by a Goodyear truck
No.
when he was panhandling, that would be some
Exactly.
really good luck on his part. But
He was just sitting there actually.
so Joe owns a house. Is he gonna let you live there with him?
No, I haven't spoke to him actually since the incident.
Oh, he gets all that money. I mean,
Yeah.
okay. Now, Mr. Potter, we know you've been in here so many times for the same behavior. Panhandling at the intersection of Broward Boulevard and Andrews Avenue, like you've done many
Yes.
times with Joe, like you've done with all the rest of the regulars. And I don't mean that in a pejorative way, but I mean, let's face it, you've been in here quite a bit.
Yes, sir.
So, do you have money in the bank, sir?
I don't, sir.
Okay.
I don't. Not at this stage of the game. Not yet anyway, not till I settle my case.
No, well.
You know?
Yeah, well, we wish you the best of luck with that, sir.
Thank you.
I'm going to set your bond at $250. I'm going to appoint an attorney to represent you, all right?
Okay, let me ask you a question. Can I get this? How would I go about getting this looked at? Because I think my orbital bone is fractured.
I'm going to order a medical screen for you, all right?
Thank you.
Yeah. Medical screen for Seth Potter, bonds $250. I'm appointing a lawyer. F.J. McLawrence, thank you. Thank you.
Thank you. I'll tell Joe you asked about him, sir.
Oh, okay. What about the other guy? What's the other one you guys hang out with?
Which other one? Little Bob? Or
Little
Robert Thomas?
Bob, what's he doing?
He's in a wheelchair. He fell out and broke his hip.
Wow. Joe gets run over by a Goodyear truck and he falls out of
Both of us.
You both did? Wow.
Yeah.
How did he end up in a wheelchair? Did he get hit by? He didn't get hit by the same truck, did he?
No, he didn't get hit by the same truck we did, but he fell out. He fell down and fractured his hip.
Well, all right. Well, look. Tell him I said hello. All right.
I will.
All right. Tell Joe I said hi too.
Yes, sir.
Take care.
All right.
I gotta tell you. Okay. Okay. Jason Levin. Jason Levin.
No problem.
Broward. Good afternoon, Your Honor.
Hi, Mr. Levin. How you doing?
I've been better, Your Honor.
Sir, you've been charged with 2 municipal ordinance violations, disorderly intoxication, false name to the police. The court finds probable cause. Are you employed at this time, Mr. Levin?
No, Your Honor. I'm taking care of my father that's terminally ill and dying with liver cancer.
Do you have any money in the bank?
No, Your Honor.
Do you own any assets? Do you have land or property?
No, Your Honor.
Okay, it says you were drinking, sir, creating a ruckus, and the police came out. This is off Bayview Drive, and they said that it says right here that the defendant continued to quote lines from Italian mob movies in a loud voice, causing the other residents to look out their windows. At one point, he said,
What we need to do is...
Don't
Is
say,
that not a copy?
I can't, I'm not going to do it in the
Sir, please
same
don't
voice.
repeat anything. Don't say anything.
How about you how about you come in? This is so.
I'm sorry, Judge.
Yes, does he have any priors?
I don't think so, Judge.
This is Jason
I'd
Levin.
ask you to RR and send him off to his trial unit, roll off with diversion so he can get it off his record.
Are you IKEA?
All right.
As long as he does an Italian voice.
This
No,
is Jason Levin.
Yes.
Does
he have anything else?
What are his priors?
DUI, and then, actually, sorry, it looks like a DUI, but other than that, traffic stuff.
Refuse. How's
All
that?
right, will you do that? What was that again, Mr. Letteray?
What's that?
What?
I'll make him an offer he can't refuse.
Okay, what's that offer that he can't
It's going to be
refuse?
diversion.
All right.
He'll take a class in the community service hours and get it off his record.
Okay, so I'm going to release him today on his own recognizance, all right? You want him to come
Thank
back to
you.
court and do this?
Yes, Judge, he needs to come back to court so he can sign up for it.
All right.
He won't be on probation, but he will be monitored.
So I'm going to release you on your own recognizance today. I'm going to
Thank you, Your Honor.
just order you don't consume any alcoholic beverages while you're on release, and
Listen to the cops.
and you know, don't watch any reruns late at night of any, you know.
Thank
any,
you. Thank you, Your Honor.
All right, sir. Thank you. Good luck.
We'll call him OG on his file.
Here we go.
We have Brady left, Judge. Della Brady? Bond?
And I think we have Sewell.
Now, two young ladies right here in the second row.
Didn't you have IKEA Sewell?
IKEA Sewell?
Page 4, IKEA Sewell.
Main jail, Judge.
Miss Sewell?
Yes, Your Honor. Arson and utilities, main jail. Stole utilities and...
Stole utilities?
Electric.
I have no papers on her. What do you have? Sewell? Was she
Yes.
on this morning and I put her off?
She's on the page 4 of this afternoon's docket. I don't see her on the morning, but I could
She
be wrong.
was here this morning, Judge.
She was? Yeah, I don't see her. Is she over here somewhere? Charged with theft of utility. The police. I see here that Florida Power and Light and the Fort Lauderdale Police think she keeps stealing power from Florida Power and Light by taking other people's meters and putting them on her own. You can put that on my conference room desk. There you go. So.
That from last year. That's as far as I see in the state system. I mean, I can
Yes.
check her
Does
in
this?
here.
Does Miss Sewell have any prior state?
Yes, Judge, I believe so. I believe she might have done the same thing before.
Represented one time a man when I was in private practice who figured out if you put it, the meter on the
Didn't
side of
do
the
this
building,
before. I don't think
figured
it
out if you
is.
turned it upside
Shouldn't
down.
do this before.
Runs backwards.
Well, now they make them where you can't turn them upside
Go to
down.
Home Depot.
But his light bill every month was like $1.75, and they couldn't figure out he had a 4-bedroom home, swimming pool, and but he only his light bill was $1.70. So they figured out that as soon as the meter reader left, he'd go out and he'd turn it upside down, and it's wind backwards, and then flip it the other way. But they make them now where you can't do that.
Electronically.
Yeah,
Not
right.
Judge, apparently the city's going to offer an adjudication credit for time served, if I'm not mistaken.
We see you more now than we see you when you're on the floor.
I need to order restitution reserved for his amount. I
Okay,
have no idea what the allegations are.
ma'am, here's the thing. You have theft in your past. So today the offer is, if you plead no contest, I'll adjudicate you guilty on both of these charges, and I'll give you time served, 1 night in jail, you're done, you're out of here today. And then what I'll do is I'll give, 60 days to...
Yes, Judge.
60 days for the city prosecutor to come back and tell us an amount you need to pay for restitution for the electricity you allegedly stole from FP&L. I have no idea what that's going to be, but when that's determined, you'll have to pay it. You'll have time to pay it down the line, but you're going to end up having to pay it. Is that something you would like to do, or would you like to bond out of jail today and come back to court on another date and you could argue against this?
No, I'll just go ahead and plead out.
Okay. So, ma'am, if you plead guilty today or no contest, you'll be adjudicated
No
guilty.
contest.
You'll have time served, and you're not going to have a trial. You're not going to have time to speak with an attorney after today. Okay? Do you understand? Now, Mr. H.,
Yes.
did you have a chance to speak with her?
I did not.
Okay. Did you speak with Mr. Landry about this?
I did speak to Mr. Londeray, and he indicated that would be his offer. I knew that she would like to resolve it because everybody who's in custody would like to resolve their matters.
Miss Ikea Sewell, I have an attorney here in court, Mr. Atria. He's a special public defender. Would you like to have time to speak with him more about this? Or would you
No.
You want to go ahead and wrap it up?
Yes.
Okay. Mr. Atria, is there any reason we can't go
No,
ahead
Your
and
Honor.
sentence her now?
No, Your
Ma'am,
Honor.
how do you plead to this charge?
No contest.
You understand it's over with right now, ma'am? You understand that?
Yes, I
I'm going to
understand.
adjudicate you guilty, give you time served, 60 days for the city to come back and tell us how much money you owe on this light bill, and then you'll get notice to come back to court, and you'll have to go to court, not this courtroom, another one, and settle that
Can we
out.
give her notice today?
Okay.
Since I don't know what her address is going to be, and she didn't have power address, I'm a bit concerned about serving her.
Well, here's the thing. I don't think we have, you want to bring it back to this court?
Okay. I would set in a trial court, but unless you want to hear it here, that's fine. I'm just asking you to set a date so she gets legal notice today, so we have to find her and
I
serve
don't
her.
know that we can give her, I don't think we
We've
have.
got trouble finding people in situations like this, Judge.
Ma'am, you live on 11th Avenue, right?
Yes.
How long have you lived there?
A year and a half now.
All right, I'm going to let it go with that, all right? So, good luck if you need to find her. Let me talk to these,
All right, thank you, Judge.
Are you ready to go?
Sure, Your Honor.
Well, you know what, let me...
Judge,
This may be
can you
quick. Hold on one
go ahead and slide over? Judge, before you move on, before you turn the page, I'm sorry, can you go ahead and sit down now, please? Elena Ivanova is on page 4 of your docket. We need to reset her for tomorrow. We cannot get a Russian interpreter
Okay, so we're
until
going to
tomorrow
reset
afternoon.
Ivanova for tomorrow. Tomorrow PM, all right? What time will we have
Thank
the
you, Judge.
interpreter? PM?
PM, yes, sir.
Got it. Okay, now, come on up real quick. We'll try to take care of which case you got.
For Jean Altanor, page 13.
Okay, so we're on that case.
You're all here?
Yes.
Okay. Can I get paperwork back? Thank you.
Oh, is that your sister? Mm-hmm.
Hi, I'm Katie.
No, just someone to bring it down. Down here, yeah.
Okay. Now, Mr. Gene Altanor,
Yes, sir.
sir, you have the right to remain silent. You're not required or expected to make any comments about your case today, about your arrest, what led up to you being arrested, any of the facts surrounding your arrest. However, if you give up the right to remain silent, whatever you say today can and will be used against you. Everything's being recorded. Do you understand what I've explained?
Yes, sir.
Now, there's an assistant public defender in my courtroom. She's here to speak on your behalf. You should allow her to speak on your behalf. You don't need to say anything. The only time you need to say anything is if we ask you a question. Do you understand that?
All right, sir.
Yes, sir.
Okay. Now, good afternoon, ma'am. Could you state your name for the record?
Good afternoon, Your Honor. Erin Veit on behalf of Mr. Altanoff from the Public Defender's
Could you
Office.
spell your last name for me?
Sure. It's Veit, V like Victor, E-I-T. First name is Erin with an E.
Okay. And now, state, this is murder, this is premeditated first-degree murder, am I correct?
Yes, Your Honor.
I see there's a warrant attached here. I've read the affidavit. Ms. Veit, it's Veit, correct?
Yes, Your Honor.
You've had a chance to read this affidavit?
Your Honor, I'm almost done reading it. There's a few more pages. I haven't gotten to the point where I see proof evident presumption grade, if that's where Your Honor was going.
Well, let me ask the state, are you seeking a foreclosed bond and release conditions?
Yes, Your Honor.
Well, then, you want to sit down and take more time to read the rest of the...
If I can just have 5 more minutes, Your Honor.
Okay. Ma'am, could you just have a seat? We'll be right
Sure,
back with
thank
you.
you.
Okay.
Thank you.
We're going to take sir, have a seat. I'll be right back with you. Take about
All right, sir.
1 or 2 minute break here, right? Okay, Mr. Altenor,
I need
come
a date of
forward.
birth on him. Joseph M. Albert.
Yes, Your Honor.
Mr. Altenor,
And this microphone
remember-
is live, so everything you say is going to be recorded, okay? So, live.
Mr. Altenor, do you recall what I just told you about remaining silent, your right to remain silent?
Yes, sir.
Okay, that still applies right now. Okay. Now, we have Ms. Viette here, and we have the state attorney, Mr. Linder. Mr. Linder, are you seeking to hold the defendant without bond
Yes.
pursuant to finding of proof evident presumption grade?
Yes, Your Honor.
Okay, now, could you state
Just,
in a brief manner why you believe there's proof evident presumption grade?
Yes, Your Honor. According to the affidavit, the alleged victim and a relative of the defendant had an altercation. It appears that this, when the defendant learned of this, it angered him, and he retaliated against the victim by shooting him multiple times, Your Honor. There's information, and the defendant was pronounced dead. One moment, Your Honor. I just had that page. It's like March 31st of this year, Your Honor, Broward, and the Broward County Medical Examiner ruled the manner of death to be homicide. Your Honor, through a 19-page affidavit prepared by Detective Gillette of the Lauderhill Police Department, police contacted and spoke with a Pierre Salvain, who's the property manager where this the shooting occurred, Your Honor. Mr. Salvain was speaking with the victim when he was shot at the time by the defendant and described the clothing that the shooter was wearing, Your Honor. Additionally, police took statement from another witness, and this witness informed that law enforcement that he knew both the victim and the defendant. He knew the defendant by his nickname, that he observed the defendant shoot the victim, that his recitation of what occurred corroborates and is the same as what Mr. Salvain told the police, Your Honor, that the defendant confronted the victim responded verbally, the defendant then responded again and then fired. He then also...
Let me ask you this.
Yes, sure.
Mr. Sylvain, what were the two names you just gave me?
Mr. Sylvain was the property manager. I didn't name the other
Was Mr.
witness.
Sylvain able to identify the
I don't know, Your Honor.
He was not.
Well,
according
it
to
doesn't...
this.
Well,
Okay, now, I'm just...
okay.
Was the other individual able to
He
identify
did,
the
Your
shooter?
Honor. Yes, he did, Your
Who's the
Honor.
other person you were speaking to?
Huntley Graham, Your Honor.
Okay, go ahead.
He was given, and appears to another officer not involved in the case, given a booklet, and he did identify Mr. Altenor as the shooter, Your Honor. Then another victim, Your Honor, spoke with Mr. Altenor after the incident. Mr. Altenor was telling him about what the incident that occurred between his relative and the victim, at which point, Your Honor, one moment. The witness stated that Mr. Altenor said that boy pulled a pistol on Syke being his relative that was in the altercation with the victim.
Right.
Mr. Altenor stated, you don't pull a pistol and don't use it. Man, he pulled a pistol on Syke and I handled that. Your Honor, I certainly think it's reasonable for the court to interpret this as an admission of the shooting. Additionally, and I would also note, Your Honor, the witness that identified Mr. Altenor as the shooter also described him wearing the same type of clothes that the property manager described him to be wearing.
I want to see if he's got any violent priors.
Anything else?
Your Honor, we have a witness, an eyewitness to the shooting that identified him, that knows him. We have another person that knows him that gave information that Mr. Altenor admitted to the shooting. And another witness that, even though it does not mention that he identified him, corroborates the occurrence as it occurred, that clearly I can't see any reasonable claim of self-defense at this point. There's no mention that the victim threatened Mr. Altenor, that Mr. Altenor just went to the scene, armed with a gun, shooting him showing premeditation, Your Honor.
Okay, Ms. Viette, do you have anything you'd like to say?
Judge, just that after reviewing the 19-page affidavit here, it seems that there's a lot of people involved, and there's a lot of he said, she said. It's very convoluted with all the people involved and all of the arguments going back and forth. None of the arguments actually involving Mr. Altenor. One of the main person.
We don't have any doubt about a couple things. Number one is we have a dead body. Number two, it was most likely homicide. Number three is that really today we're just here to identify or to determine whether or not he was the shooter. I mean, so as far as like arguments or whatever, it really comes down to, in the court's opinion, I'm just trying to clarify this and tell me if you agree. We've got several people who are there who can't identify who the shooter is. And the court did note that one person says he's 6 feet, about 100. Someone said he's 6 feet. I'm not trying to steal your thunder, ma'am.
No, go ahead.
There's one person here I noted said the shooter was 6 feet tall and weighed about 190 pounds. I'm looking at this man right here. The booking sheet says he's 6'2", 220. And then nobody got a good look at his face except one person. And that was the man named Graham. Graham allegedly picked him out of a photo lineup. Graham had met him a few times. And the other thing is, he allegedly made some admissions to somebody, which, you know, it depends on how you look at those admissions. So, is that about what you think?
Right, except that there was also another witness who describes the shooter as being 5'6" or 5'7", 190 pounds. So there's definitely discrepancies and inconsistencies in the description of the shooter to begin with. And also with the conversations or the statements of, I think it's Mr. Walters, but it could be Waiters, Darrell Waiters or Walters, who's a self-proclaimed high gang member, according to him. He was the person that had been in the altercation or the verbal argument with the deceased earlier in the day, not Mr. Altenor.
Right.
So and these other witnesses, I don't know their involvement, their credibility. I mean, the person, the Huntley Graham that Mr. Linder mentioned as identifying
Thank you very much.
Mr. Altenor as the shooter, I also don't know what his motivation or
He
bias.
allegedly knew him before this occurred, and he was able to pick him out as a photo light-up. I've got it right here. I read this rather thoroughly yesterday. I'll read Huntley right here.
Do you know his priors, his gang affiliation?
No. I'm just going to read just into the record. He saw black male. Huntley Graham said he saw a black male wearing dark clothing with a hood over his head, but his face was not concealed, walked past him. He says, he heard the black male say, "You tried to kill my brother." I am assuming, taking the state's best, the light most favorable to the state, that statement would be attributed to being co-gang members, brothers in a gang. The black male said, "What's up?" and then pulled out a firearm from his pocket. The black male fired the gun towards Dredd. Huntley Graham stated he was able to see the black male's face and also recognized his voice. He knew the black male as G. He then stated he was also known as G Mug or Mug. He explained that he mostly is known as G Mug. He also is known to hang out on certain Royal Palm apartments located just a block or two from where the incident happened. He said he knew G Mug because Daryl Waters' G. Claude Nelson knew him and spoke to him on several occasions in the past. Huntley Graham said he saw G Mug just 2 days ago in the Royal Palm apartments. Huntley Graham stated he could identify G Mug if he saw a picture of him. And then, let me see here. It says your affiant was able to locate G Mug's name. Photo lineup was completed. Photo lineup with Huntley Graham. It says Huntley Graham reviewed all 8 folders, and Huntley Graham positively identified number 4 as the person he knew as G Mug from the photographic lineup. Now, the other issue the court finds significant, and I'll let you respond to the court's observations, ma'am, is that a man named Marcus Milton said that he was a witness to some of the things that night. He said that Marcus Milton gave a sworn statement. In summary, he stated the following. I'm looking on page 15 of 19, the last paragraph.
I'm following, Your Honor.
Said he received a phone call from Darrell Williams right before the shooting saying there's a situation, something's going to go down. Milton stated he walked over to the 2500 Club Apartments and spoke with Salnav to make sure Darrell Waters was okay. Milton stated everything looked fine, so he walked back to the Royal Palm Apartments where he was staying. Milton stated as he was walking, he saw Gene Altenor, who he knows as G. Mugg, walking past him, going to the 2500 Club Apartments. Milton stated Gene Altenor asked him, where's Sykes at? Milton stated Gene Altenor said, Sykes just called me and I'm going to see what this is about. Milton stated Darrell Williams said, cuz, get over here, it's about to go down. Going down a few lines, allegedly, Altenor said to the man, man, that boy pulled a pistol on Syke. And he said, man, he pulled a pistol on Syke and I handled that. Going down a few lines, Darrell Walters and Gene Altenor are like brothers and they're in a gang. Milton describes Gene Altenor as wearing a blue hoodie, red basketball shorts with a red and black shoes on the right on the night of the incident occurred. So they put him in he puts him in the same type of clothing. This man named Marcus Milton puts him at the crime scene location. He's wearing a dark hoodie, and he allegedly makes a comment that he handles the situation. And he also has been identified by Huntley Graham as the shooter. So those, I think, are the state's strongest points. The points on behalf of the defense is we only have one person who identified him as the shooter. This other person didn't see the shooting, but they talked to him after the fact and saw him at the location. What the defense has going for it is there's only one person who saw it, even though there are a lot of people standing around, and the difference in identification is wrong. I mean, we have a man here who looks very athletic, 6'2", 200 pounds. I can believe that. We have descriptions of 5'9", 160, 175 pounds, which clearly are off. So the question becomes is, based on the case strongest issues, defense strongest issues, where does it fall? Does it make it above the line of proof, evidence, presumption? Great. I'll let you address that. I'm sorry, I didn't mean to steal your thunder, but I like to try to hone in on the issues.
No, I appreciate it, Judge. If I just may correct, Your Honor, on one issue, the identification was 5'6" or 5'7". So
my point was it was way off of what reality would be.
Absolutely.
But let me ask you, what time of day or night was this when this occurred? Do we have
One moment, Your Honor. About 11:30 at night.
11:30 at night in a parking lot. Okay. Is there anything you'd like to say, Ms. Riyad, before the court makes a decision on whether there's proof, evidence, presumption, grade?
Just what I had mentioned earlier, Your Honor, is that I don't know, we don't have any information before us. I don't know if the state's are able to pull up whether Mr. Graham or Mr. Milton are, I mean, if Your Honor is prepared just on those two statements to make a decision regarding proof, evidence, presumption, grade, I would ask that we know if what their prior record is, are they convicted felons, or do they have any gang affiliation, and what perhaps may be their motive or their bias for making such statements against Mr. Altenor.
I understand your position. The court's not going to go down that road today. The court will find proof, evidence, presumption, great. The court believes that there is strong evidence that this defendant was actually in that vicinity that night. The court notes that there was an eyewitness who identified him and picked him out of the lineup. The court also notes that there was another witness who heard what this court deems as a is an admission, though it wasn't exactly right on admission. The court looks at that and realizes that, in the court's opinion, that was enough of admission to substantiate proof, evident, presumption, great. So that's where the court is today. The court's going to order you to be held without bond for the first-degree murder of the alleged victim, and that would be Javon Douglas. And ma'am, I'm sorry I didn't ask any questions, but could you raise your right hand for me? Do you swear or affirm to tell the truth, whole truth, and nothing but the truth?
Yes, I do.
Tell me your name.
Katie Altanor.
Okay, how do you know Mr. Gene Altanor?
He's my little brother.
Okay, ma'am. I'm sure this is very difficult for you. I can tell you I've been doing this 7 years, and making decisions like this are not easy. I don't enjoy it one bit, but the court feels that it has to follow the facts and the law, and I have to make this decision today. And I can assure you that quite often, to the dismay of the state attorney in cases like this, I don't go with their request. Several times this week, I have found in very serious cases there was not proof, evident, presumption, great. So I'm not afraid to make that call when I think it's needed, but in this case, the court believes it made it to that level. Let me assure you that the attorney standing next to you is a very fine attorney who has a very fine reputation, who handles very serious cases like this. So he's in good legal hands. All right, ma'am?
Okay, thank you.
Ma'am, thank you for coming to court on this matter. Do we have another matter?
We do, Your Honor. May I just ask the court, after I was over speaking to Mr. Altanor before I came over here, if the court would order a medical screening?
I'll order that.
And if his, I believe that his Fifth Amendment was previously invoked by our office yesterday. But
I'll note that, and you know, there are, and you're saying you don't let everyone know that he's being represented by counsel if anyone at law enforcement wants to come speak with him?
Yes, Your Honor.
Okay, and also, do you want to advise him about speaking on the phone? Also?
I did while I was over at the jail, but if Your Honor doesn't mind reminding him, I don't think he could hear
Where
it
is
enough.
Altanor? Mr. Altanor, your attorney wants to remind you of something right now. I'm going to let her go ahead, and you want to go ahead, ma'am?
Oh, sure. Mr. Altanor, as I explained to you earlier, and I explained to your sister when I met her, everything you say on those jail phones is being recorded, so I just want to remind you, please don't talk about anything on the jail phones, anything regarding your case.
Okay.
To anybody.
Thank you, sir. Thank you, ma'am. All right, thank you for coming to court today. Who'd you bring with you, ma'am? Who'd you bring with you?
Oh, she's his girlfriend.
Girlfriend, ma'am, tell me your name.
Tiara Ryan.
Okay, ma'am. I'm sorry you had to meet under these circumstances, all right? But I do appreciate you coming to court and showing support, all right? Thank you, ma'am. Okay, may I see Stephen Stewart?
Sorry about that. Did you just have someone...
Judge, Mr. Stewart is present at the main.
Prior to getting started.
Let me advise Mr. Stewart of his rights. Sir, you have the right to remain silent today. That means you're not required or expected to make any comments, any statements, any explanations, any type of communication regarding your arrest, what led up to you being arrested, the facts surrounding your arrest. Now, you can stand there and not say anything, and that's respected because you have the right to remain silent. And no one can force you or require you to say anything about your case. However, if you give up the right to remain silent, you begin to speak today about your case. Whatever you say can and will be used against you. Do you understand that, Mr. Stewart?
Yes, I do.
Everything is being recorded today. Do you understand that?
Yes, I do.
Okay, you're being represented by an attorney in my courtroom. I'll allow her to speak on your behalf. The only time you need to say anything is if we ask you a question, all right?
Understood.
Okay. Now, you've been charged with first-degree premeditated murder and the court has reviewed the arrest warrant, and it says here this defendant did murder John Rickberg and shooting him with a gun, contrary to Florida statute. State,
Yes, Your Honor.
I've reviewed the warrant, I've reviewed the affidavit. Is there anything you want to say? You want to make any?
Your Honor, I would just be relying upon the what's contained in the warrant affidavit, Your Honor. This was witnessed by Denzel Williams, who was just inside the store, who knows Mr. Stewart personally, both from apparently from the barbershop that Mr. Williams works at, and also through other previous allegations that are mentioned in the report. The Mr. Williams version of events appears to be verified by the video surveillance that was captured at the Quick Mart. Additionally, Your Honor, it is verified by the other witness, Andrew Klein, Your Honor, who, while it does not mention that he specifically identified Mr. Stewart, he does also say he observed a black male wearing brown pants, low shorts, and a dark T-shirt, Your Honor, which would seem to describe the clothing that Mr. Williams said he was wearing, and that is verified by the surveillance video.
Okay. Ma'am, do you have any, are you seeking a foreclosed bond and release?
Yes, Your Honor.
Okay. Ma'am, there has to be a showing of proof, evident, presumption. Great. Do you have any comment about that today?
Judge, just with regard to the one witness who is claiming that that Mr. Stewart was responsible for the shooting, it's my understanding, after reading through your affidavit, that this has been, and there was an ongoing dispute. So again, same argument or similar to what I made last time, is that we don't know this particular witness's bias or motivation. I think that witness actually said that he had gotten into confrontations with Mr. Stewart earlier in the week or earlier in the month. Not positive the time frame there, but.
Okay, the court understands that. However, this court does note there was an independent witness who, though, didn't make a positive identification. This defendant made an identification which seems to buttress or support the identification of by Mr. Denzel Williams. So the court today will find proof, evident, presumption great that Mr. Stephon Stewart did in fact commit murder in the first degree of one John Rickberg, and the defendant will be held without bond until further order of the court. Ma'am, is there anything else you'd like to discuss today? You want to talk to your client about his rights or anything like that?
Your Honor, just to remind him again not to talk on the jail phones, that everything's being recorded, and that if his Fifth Amendment and Fifth and Sixth Amendment rights have not previously been invoked, I would ask to do so at this point, and I would also ask the court for a medical screen on Mr. Stewart.
The court will order a medical screen on this defendant. I'll write it right on the cover sheet. Okay, ma'am, I appreciate you coming in today. You've done a fine job.
Thank you,
appreciate
Anna.
it. Thank you, ma'am.
Have a nice day.
Yes, ma'am. Okay. Now, Nancy Lucette Sivert, Brian Jean Baptiste, and Angel Madden.
Judge, did we get that Creole interpreter yet?
No. Did we order Creole? Okay.
Mr. Savert needs a Creole interpreter.
Okay. We'll,
Just has, I hate to be a pain like this. I'm sure if he has to try, I know he'll let you have a copy and have it. If you didn't make a copy, I know.
We're calling again.
Yeah, just, Your Honor?
Yes.
May I have a copy of the warrant on Stewart and the affidavit on Stewart?
You see any problem with that?
the other case. I'm like, oh yeah.
Okay, may I see Brian Jean-Baptiste?
It's like my brain don't work.
Brian Jean-Baptiste. Do we have him?
Yes, sir.
Sir, you've been charged with burglary of a conveyance. Count 2 and 3 are violations of probation for resisting arrest without violence and allegedly going through the interior of her daughter's vehicle and identified as the person breaking into it. State, do you have any priors on this gentleman?
The only Broward priors I see, Your Honor, are the 2 cases that he's on probation
Sir,
for.
are you currently employed?
No, sir.
Do you have any money in the bank?
No, sir.
Who's going to help find you out of jail today?
I really don't know right now.
So I'm going to set your bond today on count 1 at $3,500, count 2 and 3, $500 per count. Thank you. How about Angel Madden?
Is Anna there?
Bonded, Judge.
Bonded. Juan Valderrama,
Main jail.
Sean McGee, and Orville Russell.
This is Valderrama, Judge.
Valderrama, you're charged with count 1 and 2 are felonies. They're both no bond. Count 3 and 4 violations are probation, no bond. Thank you. May I see Sean McGee?
Bonded. I'm sorry, North Broward.
Mr. Sean McGee, grand theft auto and no driver's license, sir. Court finds probable cause.
Shell,
I
do you
have here he has no driver's license.
Shell, do you have anything as far as
caught driving without a driver's license in the past?
Do I have what?
Right.
What was the question?
No, I'm not asking a question, sir. Let me look here. He's not driving an ATV. No driver's license. Okay. Now, sir, you currently employed?
No, sir.
Do you have any money in the bank?
No, sir.
Okay. Thank you, ma'am.
It's kind of a rough time with my family.
Okay. Who's going to help find you out today, sir?
I don't know, sir. Once again, it's a rough time with my family. Cash is not coming in.
No. When was the last time you were employed?
About 2 months ago with my dad.
What type of work were you doing?
Paving. I was going to start next week for work for him again.
I got it. Sir, I'm going to set your bond on count 1 at 1,000, count 2 at ROR. Thank you. You can bond out, all right? How about Orville Russell?
Bonded.
Okay. May I see Robert Allen, Ernest Butler, and Robert O'Leary?
Robert Allen is present at the main. We have an argument.
Go ahead.
Judge, so apparently the officer saw him in possession of a pipe. There's no allegation on this probable cause affidavit that there was anything in the pipe, on the pipe, or that the pipe was tested for any substance. So if it's just a pipe, it's just a pipe. If it can be used for any other purpose, it's not necessarily paraphernalia. So there's no probable cause for count 2. The officer says that he found a crack on the window ledge of the building behind him. Doesn't say how far away it was from him. Doesn't say if there was anyone else in the area. There's no nexus between him and what was found on the building. Okay? He says he field tested positive, but he doesn't say what was field tested positive. And so I would argue there's no nexus between what the officer found and the possession of cocaine. No probable cause for count 1. I would ask that he be ROR'd on both counts.
Hold on, State. Let me just read out of the police report. I observed the defendant holding a glass pipe commonly used to smoke crack cocaine in his right hand. While searching the area immediate, the defendant advised that he smokes crack in the pipe, and the crack is located on the window ledge of the building, which was directly behind him. Field tested positive for cocaine. All right.
Again, Judge, if there was nothing in the pipe wasn't tested. Just because he says he smoked crack in the pipe doesn't mean that there was crack smoke in the pipe. It has to be tested. There has to be something more.
Yes, sir. The court disagrees. Court will find probable cause for both counts. State, go ahead.
Your Honor, this record includes possession of cocaine 2011, possession of cocaine 2007, possession of cocaine 05, possession of cocaine 03, possession of cocaine 02, possession of cocaine 01, possession of cocaine 97, grand theft 97, grand theft 95, forgery and credit card fraud 94. Do you want more, Judge? Is that
No, that's fine.
All right.
Okay. Is the defendant employed at this time?
What was the question, Judge?
Defendant employed. Does he have a job?
Judge, he is not employed. He's been living here his entire life, same address for the past 4 years. He does have family here. He has no money in the bank, no real estate. He has no one to help bond him out.
Sir, I find at least right now 7 prior cocaine convictions. I'm going to say you're bonded $1,000. You can bond out. Thank you. How about Ernest
There you go.
Butler?
President of Maine, we have an argument.
Burglary with structure, armed, and domestic, and battery. Go ahead. What's your argument, sir?
Judge, I'm going off of memory here, but it's my understanding that Mr. Butler went to the person's house in order to recover a cell phone. His entry into the house was for the purposes of recovering the cell phone. Therefore, there is not a burglary. There may be a trespass, there may be a battery, but there is not a burglary. There has to be intent at the time of the entry before, in order for there to be a burglary. We don't have a burglary in this case. The knife that's alleged to be involved in this case was not actually involved in this case, other than having been brought to the scene. There's no, it doesn't make any sense that someone would bring a knife and then put the knife down inside the place. That knife could have come from the alleged victim. There's no way of knowing that. There's no way of proving that. It's the defendant's word against the alleged victim. So we have a situation where he's trying to recover his own property. He may have been wrong. That this person had the property, but nevertheless his purpose for entering the house was to recover his property, not to commit a battery.
So I sometimes use hypotheticals, but if we have a situation where someone feels that someone stole their cell phone and they go over to their house with a butcher knife at 2 o'clock in the morning and kick down the front door and go in and threaten the homeowner while they're in bed, even though it turns out that it was a mistake, the homeowner did not have the person's cell phone or steal it, it would not be a burglary because it's a mistake on the part of the alleged perpetrator.
Judge, in order for it to be a burglary, there has to be an intent to commit a crime at the time of the entry. There was no intent to commit a crime, therefore no burglary. That's the law.
Okay. Well, the court will find probable cause.
And by the way, I don't remember reading anything about any doors being kicked in.
No,
I didn't see
that was my hypothetical.
in the PC.
That was just my hypothetical.
This is
But I'm going to find probable cause.
It's a PBL, Your Honor.
So hypothetically, you're finding probable cause, or really finding probable cause?
I'm going to take about a 2-minute break. I'll be right back.
Yes, sir.
Okay, we're back on the record. We have Mr. Miller. Mr. Miller, I need to make a record. As a judge, I have to maintain order in the courtroom. And I do my best to be polite to everyone and treat everyone professionally. Though I'm not perfect, I do my best. I feel that you fall quite short of your professional duties as an attorney. Representing your client zealously is respected, it's appreciated. However, you go far beyond that. You make rude and snide remarks to not only the court, you make them to the prosecutor. I've seen you make them to witnesses. It's a constant, ongoing issue in here that's been going on here for many months. And I just want you to know that this court will have to take action against you at some point. If you continue to be rude, to be nasty, to be unprofessional, not only to the court, but any other attorney, any other witness. So I'm just putting you on notice at this time, sir. There will come a day where the court will take appropriate action. Thank you. Now, may I see...
Well, Your Honor, we're still on Ernest Butler.
May I see Ernest Butler?
Now, Your Honor, if I may,
Go ahead.
the court was, you were stating that you found probable cause. The only other issue on count one, it's a PBL, so it would be, this, Your Honor, I am seeking to foreclose, so we would be at a proof evident or a presumption great standard.
Please make
Your Honor, I would just be arguing that there were multiple people present observing Mr. Butler enter the house without permission. The witnesses advised he did not have permission to enter. Upon entering, he came in with a butcher knife, and upon entering, he struck the alleged victim, who was showing a 1.5-inch contusion to the outer side of his left eye and facial area. He said that he was struck approximately 25 times, and that's what caused all of his injuries. He was complaining of pain throughout his upper body. He received treatment from fire rescue. Additionally, Your Honor, the butcher knife was obtained on the scene, and photographs were taken, and sworn statements were taken from the victim and witnesses, Your Honor.
Okay.
Judge, it was my understanding that fire rescue was refused at the scene. Is that not correct?
It says Oakland Park Fire Rescue treated and released victim Goldson on scene.
Anything else?
I would just argue, Judge, if there's a question of whether he had a right to recover his property, then there is no proof evident presumption grade. It's a matter for a jury to determine, and I would ask the court to set a reasonable bond in this case.
The court will find, based on the totality of circumstances within the affidavit, there is proof evident presumption grade. The defendant committed an armed burglary. The defendant will be held without bond on count one. Count two will be $1,000, and the court will order no contact with Jacques Golden, directly or indirectly. Thank you.
Okay, there you go. Good luck. You have what we talked about.
Thank you. Ma'am, agree with that?
Okay.
Okay. Merci, Luke Tez Severt. Sir, ma'am, will you raise your right hand? Do you swear or affirm to translate from English to Creole, Creole to English, truthfully and to the best of your ability?
I do, Vivian Senage.
Okay, Mr. Severt, you are charged with abusing a child without great bodily harm and battery. The court finds probable cause.
Monsieur, le tribunal a joint que ou coupable a fait cause que ou t'es abusé un petit moun?
Non, jamais.
He said
Pas jamais
never.
fait ça.
He said
Pas
I
jamais
never
fait ça.
did that.
Do we have any priors on this gentleman? Okay. Sir, how long have you lived in South Florida?
Monsieur, combien de temps gagne de pour vivre dans Floride?
14 ans.
14 years.
Do you have any money in the bank, sir?
Ou gagne l'argent dans banque ou?
Pas en pile.
Not a lot.
How long have you lived in South Florida?
Combien de temps gagne de pour vivre dans Floride?
14 ans.
14 years.
I understand. Sir, the court is very concerned that you have allegedly said in the past that you would kill the baby.
Tribunal là est concerné parce que vous te dit déjà que vous avez tué petit bébé.
Non, jamais, jamais.
Sir, please don't say anything.
Pas dit rien, pas là.
Ok.
that you have allegedly threatened the mother of the baby to kill her.
Ou te menase maman pou te tiye li.
She claims you've hit her. She claims you physically abused her in the past.
Li di ke ou kon abuse l deja.
And that you continue to abuse her and the child by cutting off the air conditioning.
Ou kontinue ap abuse li menm avè ti bebe ap, ou exemple, ou retire air conditionné nan kay la.
And causing the baby to have great discomfort.
Ou ti bebe ap vin mal à l'aise en pile.
At one point, allegedly, you pushed the mother of your child
Te gen yon lè ou te pousse maman pitit ou a.
while she was holding the child.
Pendant ke li te gen ti bebe anamel.
They both fell down the stairs.
Yo tou lè de tombe sot nan majiskaliye a.
And the fire rescue and hospital found blood on the child, and the child was crying.
Et le ambulance vini, yo jwen sang sou ti moun nan pendant ke li tap kriye.
The court will sir, set your bond today on count 1
Tribunal ap mette garanti pou kont 1
at $6,500.
et $6,500
Count 2 at $1,000.
et kont 2 pour 1,000.
Your total bond is $7,500.
Alors total la ap $7,500.
The court will order that you have no contact,
Tribunal la pase l'ordre pou pa ge aucun contact,
directly or indirectly, with
direct ou bien indirect,
Miss Ceressier Sever
avec Miss Ceressier sévère,
or the child.
ni ti moun nan tou.
You must stay 500 feet from both of them.
C'est pour rete 500 pieds
They live,
loin
work,
de
go to
yo
school.
même, kote yo rete,
You're not allowed to
kote yo
possess any
travay,
guns,
et nou pa gen droit pou genyen e zam
any firearms
et fusil
while you're on release.
pendant que yo la ou lage nan prison.
Thank you.
Merci.
Merci,
Combien de temps
Evanot,
il dit?
Alizi.
Combien de temps il dit m'a fait là?
I'm sorry, I don't know what you're saying.
Combien de temps? How much they say I'm stay here?
$7,500.
$7,500.
Your
Ou
bond
gen
they go to bail me out.
$7,500 pou paye pou ka soti nan prison.
Combien?
Oh, he'll have pretrial release with the GPS monitor also.
7,500. Et si yo ta meto deyo nan prison, yap mette yon moniteur nan piyo pou yo konen koto ye.
Judge, I'd ask the court to reconsider. He's been living here for 14 years. He's been at the same address for 7. He owns his own home. Worked at the
Juge m'a
Cheesecake
mando pou
Factory for 10 years.
rekonsidere parce que li rete ici pour 14 ans, li gen kay pali,
He has a place to stay separate from the alleged victim while this case is
li gen
pending.
yon kay kote pou rete ki ke victime nan se pa la rete,
There's no allegation that he's ever missed a court date before.
et pa gen aucun akizasyon ke li jan manke tribunal.
I would argue that a GPS monitor in this case is overkill.
Alors map di ke pou ta met ton moniteur sou pied li, c'est trop.
Thank you. The bonds and release conditions will remain the same.
Et garanti ave moniteur
off you go.
aprete même jan.
Merci, Evanot, Alizi.
There you go. Down there, out the door.
Now I have to pay the money?
Now you have to pay the money. You go down the center, out the
What
door.
was his last name, Your Honor?
Come on up.
Alizi, A-L-E-Z-I.
Page 1.
That's this one. What about the other one I just did? What was C-E-R?
Thank you, Judge.
Thank you.
Sir, you were charged with domestic battery,
Monsieur yo chajo pour violence domestique,
giving false identification to the police,
et lè ke ou pale avè polis ou te bay mauvais identification,
the court finds probable cause.
tribunal la jwen ase koz.
Are there any priors on this gentleman?
Just one moment, Your Honor.
Sir, are you currently employed?
Est-ce ou ap travay?
Attendez.
Est-ce que ou ap travay?
Oui.
Yes.
What type of work do you do?
Ki jan de travay ou fè?
Plombine moi faire.
Plumbing.
Do you have any money in the bank?
Ou gen l'ajan nan bankou?
Michelle, do you have anything?
No, I don't have money.
Do you have any children here in town, sir?
How many children?
Do you have children?
Ou gen timoun, koumyen timoun ou gen?
Mwen gen de ti moun nan kolej Haiti, mwen...
I have two kids in college in Haiti.
Madame nan man sa mavel la, I gen 3 ti moun isi, I pak travay, I fen...
And my wife here has 3 and she's not working.
Okay. And, all right, sir. State, do you have any criminal record?
Michelle, did you have anything? I'm sorry, he's not on my
Contact
list.
with the alleged victim?
I don't know, Your Honor. And I don't know, Your Honor.
Allegedly struck Miss Blanc in the face.
Ou ba Miss Blanc kon kou nan figil plusieurs fois.
Scratched her, causing bleeding to her
Ou
back.
grafien e li tap sayen nan do.
So the court today will set your bond at $5,000 on count 1.
Tribunal ap mette garanti ou a $5,000.
$500 on count 2.
500 pour compte 2.
Total bonds $5,500.
Total là c'est $5,500.
Based on the level of violence.
Basé sur niveau violence
Court's
to faire.
concerned with the safety of Miss Blanc.
Et tribunal là concerné à sécurité Miss Blanc.
You are not allowed to have any contact with Rosalind Blanc.
Ou pas de pour aucun contact avec Rosalind Blanc.
You must stay 500 feet from her at all times.
C'est pour être 500 pieds de lui-même tout
You
le
are not
temps.
allowed to possess any guns, any firearms,
Ou pas qu'à gagner armes
weapons
physiques
while you're on release.
pendant que ou la gagne dans prison.
Thank you.
Merci.
Ma'am, do you want to make an announcement?
You have a question?
Yeah.
What is your question?
No, mwen pat, I don't have no problem with her.
Ask the judge.
Yeah. Yes, I never got no problem with her. The problem,
Parler créole.
mba gen problem ansam avèl.
I don't have any issue with her.
No, mba gen problem ansam avèl. Mamzel grafon nan do a vreman. Li grafon
She
nan
had
do
a
a,
scratch on her back,
men se pa pou di se man yem se kou mwen bal.
but it's
Li
not
nan
to
la-
say that I touched her or I hit her.
No, li nan la ri an mwen rele la vek kwa ti
She
moun yo.
was on the street, I called her.
Stop.
Campé.
Sir, what you're telling me today
So I'm dim jodi a,
are things that you should tell your attorney in
ça
a
c'est
meeting.
bagay pou ka di avocat ou.
I'm not your attorney, I'm
C'est
the
pas
judge.
c'est pas moi même qui avocat ou, c'est juge la mwen.
You may be found not guilty at trial on these matters.
Bay sa ke pase la yo ka jwen ko pa coupable.
But today is not the day to determine whether you're guilty or not guilty.
Mais jodi a, c'est pas jour pour déterminer sou coupable ak sou pas coupable.
Thank you, sir.
Merci monsieur.
Merci, Robert O'Leary.
Mr. President, the main judge asked the court to take judicial notice that the alleged victim in this case was born on April 1st, 1976, that he's been previously arrested for carrying a concealed weapon, for grand theft, for felony battery, for petty theft.
At 5:15 in the morning, that's when they arrested him. Remember, DEA got to do the breath test and everything. Probably, he'll be set for the morning.
Do we have any...
And we have an argument to make.
Your argument regarding aggravated battery with a deadly weapon, what is that, sir?
Judge, the alleged victim in this case is 20 years younger than Mr. O'Leary, who's 59 years old. Okay? According to the probable cause affidavit, the alleged victim in this case pushed Mr. O'Leary first. The alleged victim in this case is known to be violent, known to carry a weapon, and for Mr. O'Leary to defend himself, even with a knife, is reasonable under the circumstances. Now, I understand the court can find probable cause for the aggravated battery, but I would ask the court to take into consideration those factors that I just mentioned and release him on his own recognizance for pre-trial while this case is pending.
Sir, the court will find probable cause. State, do you have any...
Yes, Your Honor.
priors on Mr. O'Leary?
2011, possession of cocaine. 2007, robbery with a firearm or deadly weapon. Sentenced to 3 years state prison.
What year was that?
07.
Got it.
06, dealing in stolen property. 92, delivery of cocaine, a year and a day state prison. Just one moment, Judge. End of record.
Got it. Okay, so any ability to postpone today, Mr. O'Leary? Does he have any
Do
money?
you have any money in the bank?
No, sir.
Do you have a job?
How long have you
I
been
have a
down here in
job.
South
Where do you-
Florida, sir?
13 years.
Okay. Sir, you have a prior robbery with a firearm or deadly weapon, plus a couple cocaines. Based on the level of violence, I'm going to set your bond at $10,000 today. based on this court's concern for the safety of Mr. Joseph Albert. You are not allowed to have any contact with him. You must stay 500 feet from him. You're not allowed to possess any guns or weapons while you're on release. Thank you, sir.
Yeah. Yes, sir. One of the 30 days was taken off because it was already showing in Odyssey that it was filed. The other two, the drug ones, have not been. Surprise, surprise. Sure, Judge. Only two of them are 30 days. There's a third one that I think is a, Marvin Gray's second one.
Marvin Gray, a second look. What about the other two?
Neither has been filed, Your Honor.
Okay, may I have the orders on Uharet and Walker? Where's Nicole Walker?
Tell him you're here.
Here I am.
Hi, ma'am. You are charged with, on count, you're charged with, okay, Miss Uharet. Now, you're Miss Walker, right?
Yes, sir.
Nicole Walker, I'm going to release you on your own recognizance today, case 156705 CF10. You're released, all right, ma'am?
Thank you.
Yes, ma'am. How about Messi John Warren? Uharet?
Thank you, Your Honor.
Okay, sir, you're, Mr. Uharet, you're charged with a possession of a controlled substance. However, today I'm going to release you on your own recognizance, 156704 CF10. Your motion to release you will be granted. You'll be released shortly, sir. Thank you.
Thank you, Judge.
Sir. Okay, now, where's Marvin Gray?
Hello, how you doing, sir?
Mr. Gray, give me just a moment.
All right.
Mr. Gray, you can look something up here. Is this the second one? Yes, Judge. What is he charged with?
I think it's drug charges. Yeah, it's drug
Do you have any
charges.
criminal record?
That's what I'm pulling up right now, Judge.
Mr. Gray, do you live here locally?
Yes, sir. I stay in Pompano Beach.
How long have you lived down here in South Florida, sir?
I've stayed in South Florida for all of my life. 26 years.
Delivery of marijuana in 08. Resisting without violence 06.
So I'm going to release you on your own recognizance. You have to go to pretrial release tomorrow, downtown Fort Lauderdale, between 8 and 4. They'll give you a map right there, okay, sir? You're going to get drug tested every week. You're going to have a drug and alcohol evaluation while you're out on release, all right?
All right.
Thank
all
you,
right.
sir.
Thank you, sir.
Make sure you get that map.
All right.
Okay, where's, may I see Nikki Missiata?
Hi. Good afternoon,
Hi,
sir.
You're here for theft, ma'am. How come you haven't bonded out of jail yet?
I do not have anybody to bond me out. I don't have any money to bond out. I just
Yeah.
want to get home to my kids, though.
How old are your kids, ma'am?
My 14, 13, and 10.
Do they live with you?
My brother comes get you later.
I'm sorry?
Your children actually live with you, ma'am?
I have joint custody of them, yes.
Well, how often do you get to see your children?
We rotate. It depends on the weekend. We kind of work it out every other weekend and a couple days during the week.
Judge. She just got released a month ago on an ROR for possession of cocaine with intent to sell or deliver and possession of dangerous drugs. She was arrested at 9:40 in the morning on a Friday.
Oh, really?
Yeah.
Okay, ma'am, I'm going to let this go to your trial judge. Ma'am, would you like me to put you in the drug program in the jail?
I just want to do whatever I can that's going to get me out the quickest.
Well, that's not going to get you out the quickest. It may help you, but it may take a little bit longer. You may not get out of jail right away, but, you know, it seems to the court that you're allegedly stealing and then you just had a drug charge. So, I mean, if you don't want to, that's fine. All right?
No, I know. I wasn't doing anything at the Walmart. I don't even know where the theft charge came from.
I know, but my experience being a judge in this courtroom for about 7 years is people who have drug charges tend to steal from like Walmart and Target, and people who steal from Walmart and Target tend to have drug issues. They go hand in hand. If you don't want drug treatment, that's fine. I'm not forcing it on you. All right, ma'am. Good luck. Thank you. All right. What about?
Okay, so
you just have to wait to bond out, ma'am. Thank you. Let's see Craig Moen.
How do I wait for like another trial?
Is it Conti? Craig Moen?
He's got Judge.
Yeah.
Well, I'll wait till he gets up there.
I don't see him. What does he have? Go ahead.
I hope they do have him because we could really kill two birds with one stone today. I see he's got some marijuana priors in Broward. He's got this drug paraphernalia and an out-of-county hold. If I would make him an offer on the drug paraphernalia if he's here, and then he can go in his out-of-county hold.
Where is Craig Moen, M-O-E-N? Is he up at North Broward or Conti?
I don't have him at Conti.
No?
He's not.
North Broward?
I'm showing he's a Conti. Do you want to reset him for tomorrow? That way we can kind of resolve everything.
Let's reset him for Thursday PM.
What's the VOP for?
I don't think I didn't see a VOP. I just saw an out-of-county hold.
It says a VOP.
out of county hold and a possession of drug paraphernalia.
Then you know what? If it's you might then if you want to ROR him.
Maybe ROR him.
That's what I was saying.
Could do that.
ROR him, send him on his way.
Don't reset him. Just release Craig Moen ROR.
I didn't realize it was a VOP.
Got it. Winston Moore. Now, you know what they do in West Palm? They gave you the authority, like on a case like that, in West Palm, you could no info it, or you could no process it right on the spot.
I don't want that responsibility.
Boom, done. So it comes right out of the system. We don't have to bounce him back here.
I don't want it.
Where is Winston Moore? Winston Moore.
Right here, sir.
Not, Your Honor.
Counsel, Your Honor.
Mr. Moore, hi. Carrying concealed weapons, sir. You've been in jail 5 days. How come you haven't bought it out?
My mother and father is out of town, and I just came back from Palm Beach, and I just found a job. I have a 22-year-old daughter that's coming this way, and I'm trying to get my life established where she'll be able to look up to me.
There you go. There you go. How old is she?
She's 22 and she's pregnant. And I just found a job after 2 months doing flooring.
What type of work?
Tile works, Your Honor.
All right.
It's an overnight job.
It does beg the question.
Butcher knife, 10-inch blade. Concealed in the right side of his waist. 8:15 in the morning. Hold on, don't say it. I'm reading.
Yes, Your Honor.
Me, so I'm reading this. Reference to a possible fight between two individuals. Contact. Okay, so.
Actually, let us know what's going on when we leave them.
Seven prior felony convictions and 2 misdemeanor convictions.
I was on drugs, Your Honor. I just got clean. I've been clean for over a year on the drugs.
He's got more than that.
Who's he had? When was the last time he had something?
2012, he had a possession of cocaine. He got 38 months. 2011, a grand theft. He got 38 months as a HO.
Okay.
Everything ran through.
You want to just work it out right now? Plead no contest. Case will be over with right now. You'll leave jail this evening. But if you already been convicted of serious matters, so it's not going to really ding your record.
Yes, Your Honor. I plead no contest.
You know, we're not going to have a trial. We're not going to appoint an attorney. The case is over with right now.
I plead no contest, sir.
Okay. I'll accept that and withhold adjudication. Good luck. Thank you very much.
Thank you.
Take care. How about Scott Wade? Scott Wade?
Conti, Your Honor, right here.
Okay, sir. Petty theft. Sir, you've been in for 5 days. How come you haven't bonded out of jail?
I'm from Tampa Bay, Florida, and I just had no way to contact anyone whatsoever, Your Honor.
Okay, how long have you been down here in Broward County, sir?
I was only in Broward County for the weekend for vacation. I've been in Tampa Bay for almost a year.
What'd you come down on vacation for? Like on a cruise or just staying at a hotel?
No, we just drove down to see the beach and stay at a hotel. Two of my fellow friends from Tampa Bay.
Now your bond is only $25, and you're telling me your friends didn't bond you out?
No, they actually took my van and went back to Tampa.
I don't think it's accidental what he took.
What did he take?
Well, it's not what he took, it's how much it's valued at.
Coles, let me look here. Taney used every property at Coles. Items of the value of $299 with intent. State, did he happen to have a prior...
I could run a check, but that would be an awfully big coincidence if he just happened to allegedly take $291 less than the felony amount.
Allegedly, he took a
awfully coincidence.
shark vacuum cleaner.
We're speculating as to whether or not he had intent to be below the... I'm just saying... What I'm saying, do you have money in your property? Do you have...
No, I have nothing. I have no money, I have no way to call anyone, I have nothing.
Very coincidental. It's possible, but it'd be very coincidental.
It's sad somebody's sitting in on a $25 bond. You know, he is presumed innocent and he can't bond out. And
I understand. The defendant gave a confession, said incident. You know, of course, just kind of just thinking out loud, why would a man on vacation need a shark vacuum? But that's a whole other story. Did he have priors?
Your Honor, if you want, I can run his name in the system.
Okay.
But,
did you do that?
He definitely, I mean, he doesn't have Broward priors, but that's not surprising. He's not from Broward.
Right. Sir, we're going to run priors. Just give us a moment. I'm going to come right back. Go ahead, stay you looking.
One moment, Judge. Waiting.
Did they get him back?
Yeah, I'm not, and Judge, I'm not seeing anything. Either there could be stuff out there, but I'm not seeing it.
During Missouri tags, left the Cole parking lot, headed eastbound. The loss prevention officer was able to give a tag, description of the tag. The traffic stop was conducted where it stopped the minivan. The defendant gave a confession of the incident. The stolen items were recovered. Okay.
Yeah, I mean, I'm not seeing anything. That doesn't mean that it's not out there. It's just not showing up at the report at this
So
time.
would you like to resolve your case today? You could plead no contest.
Yes, Your Honor.
Said that quickly.
It'll be over with. We're not going to have a trial. We're not going to appoint an attorney. You're not going to have your day in court. Then it'll be wrapped up right now. Basically,
yes, sir.
Time served. Is that what you'd like?
Yes, Your Honor. Yes, I'd like to plead no contest, Your Honor.
Sir, you will have a condition. You're not allowed to return to Coles, right?
Yes, sir, I understand that.
How do you plead to this charge, sir?
No contest, Your Honor.
I'll withhold adjudication, sir. Thank you.
Thank you.
Sir, how about Andres Franco?
Yes, sir.
Mr. Franco, sir, DUI, and a DUI, I believe, with a higher breath reading. Just give me a moment, Mr. Franco.
.213210.
Okay. Sir, how come you're still in jail right now? How come you haven't bonded out of the jail?
I haven't been able to use the phone. I have money to bond myself out, but it's in my possessions. It's in my clothes.
Do you have family here in town?
Yes, I do.
Who do you have?
My brother, my dad.
Do you live with your brother or your father?
No, I live by myself.
Do you talk to your brother or your father often?
Not so much.
Okay. Okay. Do you have children?
Yes, but they're out of state.
Got it. Okay. State, let me see if he I don't think he has priors, does he?
It looks like he's had a prior DUI.
Do we know when? Where?
It just says on the, one moment. It's on, apparently, according to the report, it's on David. One prior DUI with a refusal.
When that was?
Let me check. Chastity, you don't have his driving record by any chance, do you? Judge, do you have the driving record anywhere?
Do you have the driving record on this gentleman?
All right, let me check.
What do you do for work, sir?
I'm a laborer, construction.
Okay.
I'm pulling it right now, Judge.
I'm inclined to release you and put you in pre-trial release. Just want to find out something real quick before I do that.
Yes, sir.
Oh, wow. He had a DUI property damage in Miami-Dade in 2013. With the refusal to submit and, let's see, he had a, looks like, Your Honor, just one moment. Yep. Right now, out of South Satellite, actually, it was just from May 21st, defrauding an innkeeper. He, yes, ordered approximately $62.26 in food, drinks, and hookah at
In a hookah?
It's a hookah bar, I guess they was at. So, not yet.
I had
and had no method of paying. So he's got that pending.
I had to be there on Wednesday, but I was stuck here. I couldn't make it.
No.
Well, whether or not you made it, the point still is you've got the open case for theft from that place, and now you go out and commit your second DUI. The court's not going to take any action.
Judge, would the court sign a
Go to your
order?
division judge.
Would the court sign an order to allow him access to his properties?
He can have access to his property and his telephone to make calls.
Thank you.
Thank you, sir. Thank you.
Thank you.
I think that's it.
Is that a wrap, everyone?
I hope so. If anybody has another case, they better say it quick, because I'm running out of here.
Rutledge?
What?
I don't have Rutledge.
Not on docket. Might have been deleted or something.
Okay. Thank you very much. That's a wrap. We'll see everyone back here tomorrow morning. I'm not going to be in until about 10 of 9. I have to do extraditions. Until then, we're out from 2:35. Thank you.